Thank you so much for having me. I would say save the best for last, but it's also a Friday on a holiday weekend, and where I am at, it is 2:30 on a Friday. So I'm impressed that anybody is even here. So thank you for any of you who are here. If you were in the last session, and you heard the dog barking. Actually, I'm going to share my screen. I can't promise it won't happen again, as he is now in the house. um, but I figured I would let you know what that's who you're hearing. That's who's barking. My little baby boy. Anyway, enough of that. So let's start talking about the price of not making courses accessible. Yes, he is very sweet. He is laying on my foot, uh, hugging my leg right now. But anyway, this is a presentation that I really wanted to do because I do this I do this presentation with my faculty, even though my administration doesn't want me to. But I very much believe in transparency, and sometimes it's very difficult if you are an instructional designer working with a SME, a subject matter expert. If you are bleh, if you're an ID working with an SME, it can be very difficult to explain to them why they have to make things accessible. Sometimes saying it's the law just isn't enough. Um, I very much am a teach them how to fish type of designer. So I teach my faculty how to design their courses and make them accessible. And then I assess them and things like that. And this is usually a way that I really drive the point home. Um, Now, I did not expect that there would possibly be people on the session from different countries. So these penalties are based on the United States. Um, so I apologize in advance for not being inclusive. So let's hop in. This is a short PowerPoint compared to what we did in the hidden disabilities, but it packs quite a punch, in my opinion. So if you are watching this and you are an instructor, and whether you are K to 12 or you are higher education, these might be things that you're not fully aware of. If you're an instructional designer, you are probably quite aware of the legislation, but might not be aware necessarily of the penalties. So, when I had said that administration doesn't like me talking about this, typically it's because they don't want people to hear the word lawsuit, because people can be quite litigious. But that doesn't change the fact that the law is the law. And again, once I started showing my faculty this, then they were like, oh, okay, yeah, they were super interested in making things accessible. Because if you don't give them a why and a consequence, typically you don't get a lot of buy in my experience. So, the laws that we have, again, in the United States that oversee accessibility and education with regard to design. So, of course, there is a section of ADA that talks about buildings and accessible bathrooms and all of those kinds of things. But we're not talking about that. We are going to be talking specifically about Section 504. The IDEA Act has to do with K to 12 and developing IEPs. And then Section 508 of the Rehab Act, that is where we get the WCAG standards and EIT. And if I'm speaking in a foreign language, WCAG and EIT, that's where the law talks about websites, and all of the information put on websites need to be accessible to anybody. And the standards they are measured by are abbreviated as WCAG because education is nothing if not alphabet soup of acronyms. So WCAG is actually Web Compliance Accessibility Guidelines. Yeah. Ooh, that's scary. But anyway, so let's go through this. So ADA with Section 504, this focuses on higher education. So 504 talks about there needs to be an accessibility services department. There needs to be the ability to give students access to things that they have difficulty accessing because of a visible or hidden disability. So that's the first one we're going to be talking about. So this one is interesting because not only can the institution, so the community college, the college, the university, the for-profit, so we're talking about any institution of higher ed. Not only can the institution be sanctioned with violations here, but the instructor can as well. So as an instructional designer, as a person who does professional development workshops, as the person who also is the LMS administrator, there are ways where we protect the institution, so to speak. So if the institution has been brought up on violations, the institution can illustrate that they have an accessibility services department, and then we also can save them, so to speak, by showing that we have done our due diligence. We have done workshops to educate faculty on accessibility. We utilize Quality Matters, the Oscar rubric or RSI to do course assessments of accessibility. We can demonstrate that we ourselves as instructional designers are educated in accessibility and all of this stuff when we design, and any technology that we have procured to enhance accessibility. So that's how we are kind of covered. But as soon as an instructor finds out that they can be sued as well, oh, then suddenly the instructors are like, oh my goodness, we really need to work on this. So let's talk money. So just federally, and again, this is in the United States, it's $75,000 for the first violation. For the first, there is no, oops, sorry, let me, give me 30 days to fix it. No, there is no wiggle room with the ADA. And ADA is the Disabilities Act is what most people know it as. That's the DA. Um, but yeah, there is no wiggle room for the first oops. It's an immediate $75,000 that can be to the institution and to the instructor, or one or the other, federally. Thereafter, it is $150,000. So it doubles for each additional violation. So if I don't know of any really, I don't know of any instructor except maybe an adjunct here or there who has ever just taught one course ever. So if you have an instructor that is teaching multiple sections of the same course, and each of their sections have multiple violations within them, start doing the math. If the institution cannot prove their due diligence in terms of, look, we did our part and the instructor is still refusing to do this. Now, the reason that I keep stressing the instructor so much is because in higher education, there is something known as academic freedom in the United States. I am not sure what it is like in other countries, but with academic freedom, and especially if the instructors at an institution are unionized, what that means typically is that there are not many things college administrators are allowed to look at the faculty and say, you have to do. Because a have to either needs to be negotiated in that faculty contract and agreed to, or looking at them saying, you have to do this, could lead to a grievance from the union. In the United States, most full-time faculty in higher education are unionized across the country. Adjuncts or part-time instructors are not. So that's why a lot of this can come back on the teacher themselves. In addition to federal sanctions, states and local can impose additional fines. So I have worked in Pennsylvania and New York higher education systems. And so after federal comes in and does what they're going to do, New York, let's say, can also add in fines. They can add in other sanctions like, you're not in compliance. We're going to, revoke some of the college's accreditation institute, organizations can get involved. It can get really gross. And then after that, the county, that would be your local government, in the United States. Again, I've never left the country, so I don't know how it works I've never been to the UK or anything like that. But we have counties, so that local government can come in and do even more and keep adding. So if you think about it, even if you just had 2 violations, you are already above easily. You're in the, $250,000 bracket. And I don't know about you, but I don't have that in my back pocket. And if you're an instructor, instructors typically don't carry liability insurance. institutions do in higher education. So, if you're not sure what I mean, if you think about a doctor carries insurance. It's called malpractice. So that if they get sued, if they do something wrong, the insurance helps pay for the fines. I don't have $250,000 in my pocket. Definitely not. If I did, I would be coming to you from the beaches outside my mansion. Now we're not done. In addition to that, whoever was violated, so if I'm the student in the class, I can also file a civil suit because I was denied what I was supposed to get. I wasn't helped when I should have been helped. And again, remember, this is whether it is a visible or a hidden disability. So if I wasn't given the help I needed, I can also come back and file lawsuits that the institution and or instructor, you're going to have to pay court fees, attorney fees, insurance fees if you have them. There is also the um, financial cost, the time cost. There is also the cost of potential professional development to learn how to fix those elements. Because if someone got hit for violating ADA once, probably going to be watched a little bit closer in the future. So now your reputation has taken quite a hit. In some cases, you could lose your job, whether you were tenured or not. This can be big enough that you can lose your job. You could be fired. You might also resign and get out. So I'm going to stop for a second because I want to hop back in and see what's happening. Oh my goodness. The European Accessibility Act won't be available or enforceable until next year. Wow. Would you know if the European Accessibility Act will be similar to the Americans with Disabilities Act, or are you not really sure? It might be interesting to look into that and see where they're similar, because then you can copy over some of the things that we've done. If an instructor is gradually implementing accessibility changes to their course, what would be a reasonable time frame to complete those adjustments? Not as strict. That's sad in a way. So that's an awesome question, Kelly, because a lot of the times, especially here, where RSI kicked in, and that is now a law which stands for reasonable and substantive interaction in asynchronous courses online. If an instructor is gradually working on their course, what would be a reasonable time frame to complete those adjustments? Well, if they are a full-time instructor, they're usually in the United States on a 9-month contract, and or a 10-month. So they would have June, July, and August off. They have a winter break off. Then they have, which is usually a few weeks. Then they have breaks. There's spring break, there's fall break. And I've been an instructor, so I know what it's like to have to do all the grading and all the prep and things like that. But if it's a course that you have done multiple times, you should be able to have those elements fixed 2 months max especially if you teach multiple sections, because then you can copy the same items over, or you have them saved and you can upload them again. So actually, WCAG is up to 3.0. Um, this is when the instructor, yeah, is refusing to make things inaccessible. Because just because people have to do things, oops, just because I don't know how to show that this is answered. Just because just because we tell faculty that they have to do things doesn't mean they're going to. They have to be inclusive. They have to be equitable. They have to use diversified language in a class. And they don't. Um, Change is scary. I don't like change. I don't know how to change. And I'm so set in my ways, I just don't want to. Typically, instructors can demonstrate due diligence as well, but it doesn't mean that they might be completely out of the woods in terms of fines, especially federally. Yes, yes, Gabrielle, you are correct. Um, I I'm very much a better safe than sorry. So I've already started looking at the WCAG 3.0 and following that so that this way, once it's like really out, you don't have to step your game up that much more. You know what I mean? There aren't that many differences between 2.1 and 3.0 though. Uh I hope, Gabrielle, you were the one who was just laughing. But okay, good. Because I mean no offense to that whatsoever. Um, all right, let's go to K to 12. Yeah, isn't it? Like, hey, we're gonna update. Well, I mean, even look at speaking of slow, um, I know that I said your name incorrectly in the previous session, and I'm so sorry. Um, I said Sadie, but I think it was Said. But I mean, look at how slow European is. They adopted it in 2019, and now it's not kicking in until 2025. So my big question is, what have people done in the last 6 years to get ready for what's coming? I'm sorry, but thank you for saying it's okay. I don't know. I think all the vowels together are throwing me off, but I don't mean it. Okay, let's go into K to 12. So if you design for or work in K-12, that's where the IDEA Act in the United States kicks in. So this is the one basically that says you have to offer IEPs for students, and K through 12, which is kindergarten through 12. The students don't have to self-identify. So in the United States, IEPs dissipate right when the student graduates, or I believe it's within 6 years of turning 18, whichever comes first. I'm not sure on the 6 years. I think it's by age 25. Um, so whichever comes first. But you have to, in K to 12 education, you have to give them all of the accommodations that they need, which could be extra test time, using an aid in class, using assistive aids. It can vary big time. And everything is written into a legal document called an IEP. um, which of course is another acronym. But to create an IEP, um, it's an entire group of people from the school district, the parents, and once the child turns 14, they are then invited into the IEP meetings. So it's with these meetings that that IEP is created, and it is updated every single school year, again, until the student graduates or turns, I think, 25. Don't quote me on that part. Um, so that's why special education instructors in the United States are huge hot commodities. So K through 12, all of the penalties are hitting the actual school district, not the instructors. So, again, the parents could be suing the school. So there's those funds. But where they get hit harder as far as the school or the entire district is um, public and private schools are all funded differently. But if we're talking public grade school, K through 12, or high school and middle school, the way that they receive funding is through people's taxes. So they pay school taxes. They also receive state funding and they receive federal funding. And that funding can increase or decrease based on the number of students they have in their school and or district who require special education services, or basically who have an IEP. So those funds that they get from local taxes, the state and federal, can be locked aside, and everybody who would disperse that money to the district can go, nope, we're holding it. You don't get to have it. Once you fix all of these problems, then maybe we'll give you your money, but you got to wait. And you need to fix this first. So it could take a school a year, 2 years. I mean, it depends on what the violations are. But that means money that would be used to help other students or do things in the future at that district. They're not going to get that money for quite a while. That's like one of the hardest hits in K through 12 education. Other penalties is that one way to rectify the situation is that the school district may offer a slew of other services, of course, without any cost to make up for what they lost. So, for example, if a student didn't get what they needed and they're failing fourth grade, rather than being held back or anything like that, the school may have that student get all of the services they needed over the summer to fix things and then move on. And again, I'm speaking in huge hypotheticals of what could be done. Another thing that can be done is the decision of the court is by court order that student would be removed from the school district and placed elsewhere or put in another school. And the reason why that falls under court order is if a student in the United States, if a student is going to private school, which means the parents pay the tuition for K through 12. The student can go anywhere they want. The parents can send that child pretty much wherever they want. But a public school, if the student is sent to whichever public school that whatever district the parents live in. So it's based on geography. So, um, for example, if so I'm in Pennsylvania right now. My parents live near Scranton, Pennsylvania. So if I was born and raised in Scranton, or even if I was just raised in Scranton, I would go to Scranton School District. But it didn't. I grew up in a different district, so I went to a different high school. I went to a private grade school through 8th grade, and then I went but so what that means is my parents not only were paying the school tax for the public school district, they were also paying my tuition to go to private, elementary school. Then once high school came, I went to the public school district because they had a lot more to offer. So then my parents stopped paying tuition and just paid school taxes, and that took care of everything. Um, so in that case, the court could say, okay, you know what? Even though they live in Scranton School District, we don't care. We are sending them to Valley View School District so that they get what they need, which, if you are Scranton School District, that probably looks really, really, really bad. Other things that can happen is courts can disapprove of IEP plans that are already in action and are already being used, which means everybody, that whole group of people, have to go back to the drawing board and recreate the IEPs. And much like in higher education, if I'm an instructor and my stuff isn't accessible, I'm probably going to be under higher scrutiny. Same goes for that school or that and or district. Because now all of the IEPs and all of the services that are supposed to be offered are probably going to be under a much thicker magnifying glass. All right, I'm coming back to you guys because I can't see you while I'm presenting. Any comments on K-12 or not really? Usually we don't have instructional designers in K through 12, but there are so many charter schools now that are fully online, that instructional designers do work within those types of districts. Montessori schools. There are also just online K through 12. So there can be a lot of issues that come up in grade school. I say grade school, but it's until high school. I at least just wanted to touch on it because it is one of the accessibility acts. We got anything? The ADA one was the big, oh boy, I guess. Is everybody at least still with me? Thumbs up, anything? Yay, okay, there's human activity. Okay, so let's move to the last slide where we are going to, was it Gabrielle, I think. It's time to move on to WCAG. So 508 of the Rehabilitation Act says that things that are online. So this means websites. This also means stuff that is on an LMS, learning management system. So if there are materials that are accessible online, they have to be accessible. That's what 508 says. And again, those standards that Gabrielle and I were talking about the WCAG 2.1, 3.0, those are the standards by which the accessibility is measured. There are also the formation of EIT standards, which is electronic and instructional technology. So this is where like grabbing all of those accessibility software and putting them inside an LMS like ReadSpeaker, Boost Lingo, ReadWrite, Orbit Note, Blackboard Ally. There are tons of them. Even just putting the captions on while in a Zoom session or something like that. So this again can be to the institution and the instructor. Now this can be K through 12. It can also be higher education. So if you go to a school district's website, it has to be accessible. If you've ever tried to access a website on your phone and there's a spot where it says, do you need mobile friendly? That's part of Section 508. So this can be in addition to the ADA fines from the other slide. So the other slide was federally 75,000 for the first violation and 150 for each additional violation. So this one's a little cheaper. So first violation is 55,000. Each additional violation is 110,000. And in this one, federal funding and grants can be revoked, which again, I don't know about other countries, but in the United States, higher education, businesses, corporations, they use a lot of federal funding and tons of grants, especially nonprofit. So the Alzheimer's Association, the Autism Association, all of those not-for-profit associations, those were just the first two that popped in my head because I'm living in the A's apparently today. But those all operate on federal funding and grants. So all of those can be revoked. There again can also be lawsuits. So the institution and individuals, but this time they're sued not by the people, but by the Department of Justice. So typically what happens is the Department of Justice finds out about it because people can report the violations to the Department of Justice. So similarly, I was talking about medicine before. Comparatively, in medicine, if there is a HIPAA violation, people don't find out about it unless the person goes to the HIPAA website and actually reports a violation. That's how the Department of Health and Human Services finds out about it in the United States. So in this case, if a website or an item that is information technology, if it's not accessible, they can report it to the Department of Justice through a form, and then that's how they get involved. Of course, again, there are the same types of non-financial costs, regulatory scrutiny, fixing web page and course elements. In the United States, there is a type of accreditation for online courses called NC SARA. And when you are completing that accreditation form, you have to attest to and prove that your front-facing website and all your websites for the school are within WCAG compliance, and they come back and check. There once, um, when I had first gotten NC Sarah accreditation for an institution, um, they came back and they're like, this website isn't quite right. We'll let you fix it. So they let us fix it because it was a very small, super minor infraction. So they let us fix it and submit it without any financial consequence. Basic, like we had the web extension incorrect on a form or something like that. So it was thankfully very minor. But it can happen. So that's the end of PowerPoint. I am going to come back to you guys and stop sharing. I'm going to breathe while you ask questions or whatever.
There was an early question that I don't know if you answered from Gabrielle, where it says, is this when the instructor is refusing to make things accessible if the instructor can show they're taking classes and working to consistently meet what
WCAG
WCAG
2.1
WCAG
AA
standards? Yeah.
Yep. Yes, I did answer this earlier. I wasn't sure how to mark it answered.
Okay.
Yeah, I did answer this. Luckily, Gabrielle commented in the chat with me. But yes, the answer was yes, because it's when I don't want to change, I don't feel like doing it, those kinds of things.
Right. Right. I'm wondering, I mean, and I don't know, sorry, I was kind of going back and forth with a couple of things here, but what, have you seen, like, I mean, do you know of anybody that's actually been fined or gone through this? Yeah. Okay. Those are some major.
Oh, yeah.
Major
And
nods.
the other thing is, the school was a for-profit that got nailed for WCAG. So they got hit for the Section 508. And when you get hit with those fines, those penalties, those infractions, you have to somewhere publicly where all employees go. So for us, it was in where our mailboxes were and our photocopier was. It was hung on display that a violation was found. So yes, you have to make it public that you literally broke the law.
It's pretty intense.
It is, especially when you think about, and that was in like 2017. Like that was somewhere between 2011 and 2017. If you fast forward to now, how many more courses and how many more websites there are. And if you think about that first slide I showed, if you think about violating ADA and you have violated Section 508 and you put those fines together, that's intense.
Yeah. Wow.
That I've never been a part of. But so for the ADA, when I had talked about instructional designers, we can kind of illustrate the due diligence. I definitely had files that were sent to people above my pay grade to demonstrate, here is where I have helped our institution meet our due diligence. And then if the instructors choose not to, the instructors choose not to.
Let's see. Kelly just posted
I'm
a
like,
link.
what did Kelly just throw in here?
Oh, interesting.
Ah, awesome.
Huh.
I wonder if.
Wow.
I wonder if they went, look at Harvard. Woo!
So, Kris, I've we've never come across, okay, so we've done AIDC 4 times. We've never talked about this topic has never been covered before. And I've never seen, I don't think I've seen anything else come through that is was specifically focused on this. I don't know if anybody else has that is in the audience, but
Well,
I mean,
Kelly's
we've
link just became a new resource for me.
what's that?
Kelly's link just became an awesome new resource for me.
Yeah, yeah. I mean, how often do you run across this information? Like this particular subject matter? Okay, there. Gabrielle says did that I don't know how to pronounce their name, but Deck
DQ.
or DQ did one recently
DQ.
about the new rule.
So DQ University is a training site for I'm sure internationally. They do a lot of trainings, but you have to purchase subscriptions to DQ to get those trainings.
Right. Right. No, it's fascinating.
Only once personally have I come across this, but with Kelly's link, you can see that this is not uncommon that this happens. And I'm surprised. I wonder, well, the place I worked for isn't on the list. Um, but you do really, and I don't want to badmouth anything, but you have to be very careful of the fully online schools. University of Phoenix, Capella is actually on this list um, of of lawsuits. Um, University of Phoenix is on here as well. Um, so some of those for-profit, fully online schools uh, are be cautious of the place I was working for that I know firsthand was also a for-profit, and they're not on the list. Yeah, surprisingly.
Yeah, this is quite a collection of
So
lawsuits.
yeah, it happens. It is not uncommon, and I'm actually really shocked that you've never had a presentation on this.
Yeah, no, no one's ever submitted anything to talk about it before, so that's one of the reasons why I thought when you had given me your list of things to speak about, I'm like, okay, that's one we've never come across. So I think that we've kind of been we've probably had people spoke that like WCAG definitely, but just like lawsuits and just the cost of it entirely. I didn't realize the fines were as extensive as they were. So this is good
And
stuff.
administration, when you work in higher education, and Kelly, yes, Penn State is really great with accessibility and like on it. Um, but uh, usually at the higher education level, they don't want you to say the word lawsuit for whatever reason. And I'm like, I was trying to teach about why I was implementing Blackboard Ally to show people how accessible their documents were within our LMS. And luckily, one of our faculty was an attorney, and she brought it up
Mm.
in the workshop when someone was like, I don't want to do this, me. And she goes, fine, get sued. And suddenly everybody went, what? And she looked at me. I went, thanks. And then I was able to explain more. And then suddenly everybody was on board.
Yeah.
Because, but I don't like not talking about it because I feel like then I'm hiding what the real consequence is. This is
Yeah.
not
Right.
just oh, if I don't do it, it's no big deal.
Hmm.
It is.
Interesting. Wow.
And that
Very
doesn't
cool.
even talk about the penalties for RSI because that is a law as well. with online asynchronous courses. So
Penalties with RSI? Ooh,
so RSI came out, that was a federal law for reasonable, it stands for reasonable and substantive interaction in online asynchronous courses and synchronous.
wow.
So you can't, basically, they're making the distinction. RSI legislation makes the distinction between what would typically just be like a correspondence course and a real meaty online course.
Wow. Hey, what did that RSI stand for again? Can you, I'm got to take some notes here.
I'm going to pop it in the chat.
Okay, great. Because I hadn't heard that one either.
Reasonable. And has anybody heard of it? Any thumbs? Nobody's heard of this?
You're not making it up, are you, Kris?
I'm looking up the website now. I am not.
There it is. There it is. Okay.
It's not fake.
It's good. Good to know.
It's not fake. Are you making it up? No.
Requirement for online courses that receive federal financial aid. Okay.
Here is actually, yep, I'm about to put a link in the chat from Eric. It's a PDF that explains the guide, like basically the guidelines.
Oops, that looks like that might be a direct link to. Oh wait, sorry. I just saw that it was a Chrome extension there. Let me see if that works.
It
Yeah,
is
it pulls it up.
regular and substantive interaction, backgrounds, concerns, and guiding principles. It's from the Online Learning Consortium. That's the group that actually created this act.
The OLC.
Within so the OLC is within the Department of Education in the United States. I keep clarifying because there are other countries here. Gabby wants to know if you grabbed all of the links from the conference this year.
Let's see here. Losing grab all the links from the conference this year. You know what? Usually, who was it? I think Cindy does, Cindy Nagel, but let me check.
How can I mark her answer?
Yeah, I'm not seeing her in. Let me find out too if anybody, there might be something, Gabrielle, that I know that I did post some links like related to the presentations. There you can find links in some linked to some of the recordings, but let me check on that, because yeah, Kris, you've shared some great resources with us last session and this session, and we've got to wrap things up because we've hit our time. And thank you for being generous with your time and sharing with us to close the event out. Thanks everybody for being here. Let me take a look. Oops, chat. Yes, Gabrielle, thank you. Yeah, and thanks for attending another training, learning, and development conference. Community conference. We'll definitely be doing AIDC 25 again next year. I know that I think September 16th we have coming up what was it called? The evolution of workplace learning. That's coming up here at TLDC, and that one should be a really good one as well. I've seen some pretty compelling topics and speakers already joining for that one. So make sure you stay tuned for that in the newsletter and all the other messaging that we throw out there to make sure you can register for that one for free. And with that, I'm going to go ahead and close out the session. Thanks again, everyone. Have a great weekend, and we'll see everybody next time. Thank you.